So the disadvantages are, if a person finds something on your property, perhaps an unattached chattel, then they'll get 50%. Of course, the rules could be clarified, but the principles of order will always be distinguished because there are always situations where it will be unfair. So if you follow the order principle strictly, it'll give rise to particularly inequitable results in some circumstances. So if you just say, if you find something that's on private land, it's a 50-50 split, then there are going to be circumstances where it's just blatantly unfair. And we also already have the option for a 50-50 split, which is settlement. So moving on to the intention cases, we have Bird versus Fort Francis, R versus Christie, Moffat and Kazana, the Attorney General of Canada versus Brock, and Weitzner and Berman. So, Bird and Fort Francis, there was a 12-year-old boy climbing underneath a building while he was playing with his friends. He found about $1,500 that he took home with him. It was cash placed on the understructure of the building. He gave a substantial part to his mom and then went out and spent a whole bunch of money. A police officer noticed, and he was an employee for the town of Fort Francis, and asked the boy where he got the money. The boy told him the truth, and without a search warrant, the police officer went and asked the mom for the money, which she gave to him. They tried to find the true owner and couldn't, and the boy asked for the money back. So the judge usually determines that the boy is not the true owner, or, and I say true finder here, but he's not the true owner because it was not found in public, it was found on private property, and because there's no reason to believe that it was lost in a true sense. It looks more like it was placed there deliberately. So who has established a possessory right and when? So the owner of the property, the money was placed there deliberately. You could argue it's unattached, but if it is attached or placed there deliberately, then manifest intention applies. But he's dead and not a party to the action, so his rights don't apply. The boy, yes, has established possessory rights by taking the money home, hiding the money, and keeping the money with an obvious intention to exclude. And when did he do this? Before the town, through their police officer. So the mom, does she have possessory rights? Maybe she received the money from her son. Did she have the intention to exclude? It's unclear. The court determines that it doesn't really matter anyway. They can both be considered joint parties, I suppose. Though our teacher did say that she probably just had custody of it, and the court didn't find it was important enough to determine. So the town, they might have a possessory right. They took the money from the boy and mom. However, they took it without a search warrant, and they did have the intention to exclude others. They deposited the money in the treasury after the true owner wasn't found. So the other thing to consider is, does it matter if it's felonious? No, it doesn't. Not when these are the only two parties to the case. If the true owner was there, then yes, it would. Though it doesn't matter, how do we determine felonious intent? And it's by not turning in the money. I suppose also because it's on private property. So note Bridges and Hawksworth, Hannah Peel and Parker case, the findings are immediately given to someone to find the true owner. So the decision is for the plaintiff, the boy. They return all the money to the boy, and the rules here are basically to identify all the parties and determine their rights related to each other and the object along a timeline. You can bring action to recover something you attained feloniously, and felonious intent is determined by whether or not the finder makes an attempt to locate the true owner. Great. R versus Christie, this is the marijuana in mom's trunk. Mother found a large quantity of marijuana in the trunk of her car, assumed it belonged to her son. She drove around the city for an hour looking for friends from whom she could obtain advice. There was an automobile accident, and the police found the marijuana in her trunk. So did she have possession of the marijuana? And I guess it's important to note that this is a criminal case. And what the court decided was that no, she didn't have possession of the marijuana. It's clear that it was in her car, but she had no intention to exercise control over the marijuana, and this is debatable. Obviously, she had intention to control it until she decided what to do with it, but when caught, she was perfectly happy to give it up. So this is a criminal case, so the mens rea is a little more difficult to prove. Was there reasonable doubt that she intended to control it? I suppose so. So the decision was that she was acquitted of charges of possession of narcotics for the purpose of trafficking contrary to provisions of the Narcotics Control Act. And the rule here is that there's different measures for intention to exclude between torts and criminal law. And custody does not necessarily equal a valid enough mens rea to create possessory rights. And we also saw that in the Moose case, where someone else had custody but didn't have possession. Moffat and Kazana buy a bungalow with a biscuit tin of money in it. So Kazana purchased a bungalow for Mr. and Mrs. Russell in 1961. 3 years later, during renovations, a biscuit tin with about 2,000 pounds in £1 notes was dislodged, and the money was turned over to the police. In due course, it was turned back over to Kazana, and the Russells brought an action to claim that the money was theirs. So who has the first possessory right here? The person that placed the money there. So the judges believe that Mrs. Russell, as she recounts the story of Mr. Russell retrieving the money, they believe that that's true. So the money did belong to them. They were the true owner of the money. And once that happens, it's difficult to extinguish it. You need to use a positive action to abandon it, whether by lighting it on fire or throwing it in the garbage or giving it to a friend forever or something along those lines. Or your possessory rights can be extinguished if the statute of limitations has passed. And there's lots of rules around statute of limitations, but generally it's 2 years after you could possibly bring a claim, which means you need to know about the injury or harm that's been done to you. So what about the actus reus mens rea? Once you establish your possessory right, you no longer need to maintain your intention to exclude others. The intention is assumed, and thus the decision is for the plaintiffs, the original owners of the house. So the rules here are that though intention to exclude is an important aspect of establishing your possessory rights, once those rights are established, you no longer need to demonstrate that intention. You can only give up your possessory rights by a positive act of abandonment, or if you accidentally leave the object somewhere and the statute of limitations to bring action for its retrieval passes. So in this case, merely forgetting about it to the point of you sell your house with $2,000 up in the chimney is not enough to extinguish your possessory rights. And one of the reasons for this is that you don't have to remember all the things you own. So, if you can't list all the things in your basement, it doesn't mean that your possessory right is extinguished. So Canada, the Attorney General versus Brock. This is $300,000 in a trunk. Brock was pulled over for a traffic violation. The police lawfully searched his trunk and found $300,000 in cash. He said it wasn't his and the money was taken by the police. He later reversed the statement with a lawyer and said he was holding it for offshore investors. 2 weeks later, he was found dead from cocaine overdose, and the Brock estate is looking for the money. The municipality that employs the police officers also claimed the money. So at trial, they decided that manifest intention applies to your automobile. Now, I'm not sure what they said about whether it being attached or not attached, but presumably it was either attached or doesn't matter. And that your manifest intention is to exclude others of anything that's in your automobile. So the money was never lost, Brock had possession of it, and thus the Brock estate is entitled to the money. On appeal though, however, the courts, according to our professor, pulled some strings to get the money for the municipality. They treated the car as a semi-public property. So as we note from Parsons, originating from Ward Simmons and South Staffordshire judgment, you can't have manifest intention over property when you invite people to be on that property. So if it's, in the case of an airport, it was not private enough to have manifest intention over the objects in it. So here, because he loaned out his car, and therefore it's possible that he was unaware of the money, so therefore the control or the desire to exclude weren't present, simply because he loaned out his car. The decision goes against the Brock estate, and the rules here are, when the lines are grayish, the court may stretch the definition in either direction. Depending on the usage of your private property, you can compromise its private nature and the legal assumption of manifest intention. So Weissner and Herman, the facts are, this was an elderly woman in Stratford, Ontario, and this is a case from 2000, so it's quite recent. She sold her home, and the purchaser hired a contractor to tear down the building. In the process, they found a fire extinguisher with $130,000 in it. The contractors were a little deceitful and gave her back old photos, but no money. She found out that they had found $12,000. They agreed to give her a third of it if she signed a release saying the money represented the full payment. Later she found out that it was $130,000 and was suing for that amount. So the courts decided on the balance of probabilities. The elderly woman was the person who hid the money, so she had to establish that the money was actually hers to begin with. And they decided that she was the true owner, I suppose. And there's another sort of, so now we need to kind of figure out the relationship between the elderly woman and the people who brought the house and the contractors. So the fact that the widow did not know about the money did not prevent it from passing under her will and extinguishing her rights. So no agreement existed between, existed that the contractor could enjoy salvage rights. Also, as widow and purchaser were not aware of the money, the possibility of including it in the transaction for the property sale was not contemplated. It seems to contradict the fact that she's the rightful owner, but anyway. While there might have been delivery of all chattels in personal residence, there was no delivery in law of money. So presumably the sale contract said all the chattels belong to the new owner, but I suppose money is different than chattel. So the court ordered the purchaser to return $130,000. So just to come back here, I suppose the rules we can look at here are that so this is very similar to the Kazana and Moffat case, where a person owns something and leaves the house forgetting about it, presumably, but their intention to exclude others and their possessory rights are not extinguished simply because they forgot about it. So we worked through a potential exam question in class, and here are the facts here. Ann Abbott is a leasee, owner-occupier of 12,000 square meters, or acres. And it's worth noting that in adverse possession, you can actually get ownership of the land if it's unoccupied and you spend a lot of time on it. Anyway, that's kind of a side note. But she runs a camp, and Barb is a camp leader. Barb goes on a 3-day hike with a bunch of girls. Little girl Jan, while they're camping, lifts a piece of birch bark where she's sleeping and finds a leather bag. She calls for Petra, and Petra calls for Barb. They open the bag together and find gold coins. The land that they're camping on is leased from the Great Northern Development Company. The land that the bag was found on is another unoccupied, unfenced property owned by the Great Northern Development Company. Ann Abbott is claiming title to this land and the coins. We're going to assume that she gets the title to the land, so she's just claiming for the coins. So the process to go through to answer this question as you're reading it is to, first of all, know how to know what facts are relevant. And that's going to come from the issues that we discuss in class. So noting attachment issues, noting the setting is important because if it's inside a building or outside of a building. Noting the relationship between the parties is important, for example. So we underline the names of the parties, note what their relationship is, underline the setting, location, underline the timelines, and consider drawing a map. And when we're underlining here, we're making connections between the facts of this the facts of this circumstance and the cases that you already know. So when you underline something, make those connections. Whenever you're underlining it, try and make some connections. And finally, what is the actual dispute? So to answer the question, after that, take 5 minutes and organize your answer on a scrap piece of paper. Clarify the structure and organization of the cases that you'll be citing. So note the cases that help answer a relevant question are relevant and the other cases are not. It's very, very, very important to answer the other side too. Don't jump to conclusions. There's always, whatever the facts are in the case, there's probably a reason for those facts being included. And I know that I tend to lean towards the strongest argument and just try and figure out who's going to win and what facts or which side does the law help. But we need to dig into the other side by challenging the facts. So if all the law is on one side or is for one party, there may be some law or there may be some cases that support the other party. But if there really isn't any, then you have to start challenging the facts for that other side. And this is because the judge can go other side and we never ever just pick one side. The best lawyers knock out the other side's case, which means they need to know what the other side's case is going to be. So don't write the facts again. Your opening paragraph is to organize the document, prepare the reader for what they're going to read, but don't give the answer just yet. Also, the answers are rarely unequivocal, so there's going to be some ambiguity, there's going to be a strong case and a weak case. Make sure to use headings to make it easy for the reader, and pretend that you're a lawyer. Pretend that this is fun, and pretend that Anne is your client, or and the other person is your client as well. So it's a bit of a game. Kind of argue, go in with all your knowledge and sort of argue back and forth and enjoy it. Learn the principles and play them back and forth.